All right, good morning, ladies and gentlemen. Welcome to session of the Supreme Court of Georgia. The second case for this morning is Pilcher versus Stribling et al., case number S06G1482.
Edwin Marcher and Michael John Puglise for petitioner, Paul Lee Rosenthal for respondents.
Good morning, Justices. Mike Puglise for the appellant. Justice Carley, you hit it right on point. Most certainly there is a vague situation to be in. What do you distinguish? What is physical acts? What is most certainly abusive language? And the Court of Appeals did miss it on that point. I think speaking from a position of being a prior policeman, being told, Justice Sears, to get up at 5 in the morning on a repetitive basis to be on a surveillance, being told, Justice Hines, to do more push-ups and to run an extra mile or an extra 2 miles, all on a repetitive basis. Fire Chief Pilcher was a disciplinarian. It goes to a legitimate purpose of what he was trying to do. And that legitimate purpose was his training, to train his men. Did he use the proper language? Well, it's yet to be seen. It depends on the environment you're in. You're in an environment that's most predominantly male, predominantly a paramilitary situation, and most certainly everybody that contributed or was there present chose to be firemen. They consented to be firemen, Justice Melton. They chose to be there. That's the consent. And this, if you kind of follow the history of the stalking statute and you look at it, it most certainly goes parallel with the Family Violence Act. Family Violence Act, you had to be a resident. You had to live with the subject you were seeking the protective order from. So the next step, if that didn't occur, you have a boyfriend, a girlfriend relationship. They don't live together, but the boyfriend continues to follow the girlfriend to Applebee's or to her workplace. Then it becomes a stalking situation. Most certainly, I can't see the legislator looking at this and saying we're going to make this an employer-employee situation. There are other remedies. There's remedies if you're talking about a situation that was brought up of a sexual nature, where you're ordered to come into the employer's work spot. Most certainly there's Title VII remedies in the federal systems. There's Georgia labor laws. There's other remedies for that. But in this situation, basically you're handcuffing the fire chief and you're telling him that he cannot discipline and supervise his men according not only to their safety, but to the public's concern, which leads us to another thing. My esteemed colleague brought up the point that this in no way has affected Chief Pilcher's way to operate his business. It has. If you read that order carefully, he has to have a chaperone. Now, the first question that came to my mind, if he shows up at the fire first, and he doesn't have that chaperone with him, and one of the protected parties shows up there, does he leave the house? Let it burn? What does he do? So most certainly it does put restrictions on him and prohibits him from doing his job effectively and serving a public need. And that's what the question goes to. And in this case, I believe that the Court of Appeals most certainly missed this call totally. And you bring up another thing. It only gets worse. It puts Chief Pilcher on a big wheel, a revolving wheel now. And what happens is he is subject to aggravated stalking under this rule. If he weighs a public need, I stay at that fire, regardless of what that order says, my chaperone's not there, and I'm with the protective party. Do I stay there or do I face an aggravated stalking charge? Most certainly there was consent there, and I believe the justices are looking at it correctly, especially Justice Carley. When you cited that this was a vague, it puts the employer in a situation. Where do you draw the line on what is overlying physical abuse or abusive language? Where is that line drawn? That's all I have. Thank you.
Thank you very much.